The Honorable Brian D. Lambert, Judge presiding. All persons having business before the court draw near, give attention and be heard. May God save the United States of America, State of Florida, this honorable court. Please be seated.
Good morning. Welcome to another session of oral argument before the 5th District Court of Appeal. As our marshal just indicated, I am Brian Lambert. I'll be presiding today. I did such a good job Tuesday, they wanted me to come back for encore to preside on Thursday. So here I am. Let me introduce the panel. To my right and to your left is Judge John Harris. And to my left and your right is Judge Adrian Soud. We have two cases. Today is, for the record, Thursday, February 26, 2026. We have two cases remaining on the docket. Each side will have 20 minutes to present their argument. Appellant, we typically reserve 5 minutes as a default amount of time for the rebuttal. If you would want a different amount of time, just let me know and the marshal will adjust the clock accordingly. When you get into your rebuttal time, you will see the yellow light go on. And you know, that just tells you you're starting to use that amount of time. You don't have to immediately stop. You know, if you want to continue on, you certainly can. If you use all your 20 minutes, you don't get any rebuttal time. So just kind of keep that in mind. I'll try to give you the heads up when the yellow light comes on if you're in the midst of things. We are being live streamed, so if you have any type of electronic devices, anybody in the audience or any counsel, please put those on mute or turn them off, at least during the course of the argument, so that the counsel and the court are not interfered with any kind of inadvertent communication. Okay. That being said, our first case is number 24-2078. Kachina, I apologize if I'm mispronouncing that, Kachina Starr versus Florida Hospital Healthcare Partners, Inc., DBA Advent Health Medical Group, and Kisaki Kurian, and I apologize if I'm mispronouncing that, and please let us know if we are, and we'll be happy to correct our use of those names. Mr. Lee, whenever you're ready, sir, proceed.
Thank you, Your Honor. Good morning. May it please the court, my name is Brian Lee. I'm representing Ms. Starr in this appeal. I'll go ahead and have the default 5 minutes for rebuttal.
Thank you.
Thank you. So this case comes to the court from a trial that occurred where there was a defense verdict, and afterwards a motion for new trial done on various points that we brought in this appeal. I'm going to focus most of my argument regarding the first couple of points, one meaning the testimony of Dr. Kurian as well as testimony of Dr. Kurian's expert, Dr. Dewar, and in relation to not only the testimony in direct but also what he said regarding opinions of
Before you jump into that,
Yes.
just so I understand the chronology,
Yes, Your Honor.
Mr. Starr, on March 16, 2018, he fell unconscious for a few seconds. That then prompted him to consult with his primary physician, Dr. Fruhan, the following day. Mr. Starr had an EKG that day. He was referred to Dr. Kurian, and Dr. Kurian, the appellee in this case, saw Mr. Starr on March 21 of 2018. Mr. Starr passed on March 27, 2018. Is that the only consult on March 21 that Dr. Kurian had with Mr. Starr?
That's correct. Yes. And the case centered, or at least the pleadings in the case centered around the stress test that was done by Dr. Kurian on that date, about the electrodes and the leads and the misdiagnosis through that. So yes, that was the negligence that was pled, and that was the negligence that was put forth by Ms. Starr through her counsel in the proceedings. The testimony that when we look first to the first instance about Dr. Kurian is what happened after that. And as the court knows, after Dr. Kurian performed his test, he said that the test was normal, sent him for further treatment if he needed it. And so Mr. Starr had further new symptoms, went to a doctor had gone before, the same urgent care center, saw a physician's assistant, Mr. Dyer, and who was below the doctor who you mentioned before, Judge, and there were new symptoms, and the medical records are pretty clear that Mr. Dyer said, you can go to the emergency room. Mr. Starr said, I didn't want, or he declined. That's what it says in the medical records. So there was a part of this case that talked about Mr. Starr and what he could have done, should have done. That was allowed by the trial court. That was certainly a focus of it. But
And there was not objection to that, if I understand it, if he would have gone to the emergency room, at least from the plaintiff's experts, that day, after seeing Mr. Dyer, the PA, he very well could have survived.
right, that is.
Wouldn't have died the next day, likely.
Right, and yeah, there's and actually the defense, sort of really from the beginning of the case, said, look, if he would have gone to the emergency room, they would have put him on a telemetry, and they would have seen what was happening, and more than likely he survives. That was what the case was. But what the trial court and as the court has seen in the record, there was sort of a back and forth. We filed a motion in limine so that Dr. Curran could not put Mr. Dyer or Dr. Frohan on the verdict form because this was a subsequent tortfeasor kind of situation after Dr. Curran, now it's them. And
Let me ask.
Yes.
I mean, I know issue 3 is the verdict form, the issues about the verdict form. Who actually prepared the final verdict form that was used? Was it the plaintiff's side?
I think it was both. I think it was both sides. And we're not saying that, just to be clear, we're not saying that the verdict form was, like the form of it was objected to, meaning that both sides didn't have a hand in it. We're not saying that. What we're saying is that upstream of before that happening, the trial court allowed Dr. Curran through his testimony to get into things that the trial court had said previously he wasn't able to get into, meaning what Mr. Dyer did, quote, wrong, didn't tell Dr. Curran, which was a sort of a focus of it, and what Dr. Curran would have done if he would have heard that. And so when we're looking at the testimony, and we've put it into the brief.
Did that become a feature of his testimony, in your estimation?
I believe it did, because from the beginning of the case, there was always this argument that Mr. Starr, and it was focused to Mr. Starr in the opening statements, but that if Mr. Starr would have gone to the emergency room, if he would have heeded the doctor's advice, then this would have happened, right? He would have been put on there. He would have survived. And so the defense has always had that as a core defense of the case.
And just so we're clear, Mr. Starr is not a Fabre defendant.
He was not.
And the verdict form, I mean, it's kind of a, in the old days, before comparative negligence, you had contributory negligence. So if the plaintiff was 1% at fault, he or she lost.
Right.
This was almost kind of a reverse scenario that if Dr. Curran the jury thought, well, I know you're pinning the blame on Mr. Starr, but you're on it too, pal. And if in their mind, they just thought, well, he's 5% negligence, but the way the verdict form read, if they checked yes, then it's 100% liability for the damages. So
Sure, that's the way the verdict form is set up. The way that
kind of inured to your benefit in that respect. Not yours, but the plaintiff's side, I mean.
Sure, no, and I would say, Judge, that it was the problem we saw, and of course this was argued, is that they were allowed to bring Mr. Starr as almost what you would normally do with a Fabre defendant without actually putting him on the form. Right? They did.
You could have asked for him to be on the form.
We certainly could have.
I know you're not the trial lawyer. I mean, but you're here obviously on behalf. But yeah.
Sure, but that just wasn't something that was. I think, frankly, wouldn't have been done anyways, because I mean, I don't know of most plaintiff's attorneys.
I get it. The gut reaction. If you don't want to attribute fault to my client, hey, good deal. But
sure.
In the big picture, in light of what the focus was of the defense, that Mr. Starr could have avoided his own demise, for lack of a better term.
Sure. And that certainly was something. And look, that was
That was
something
their
that
argument.
going to be
I
through
mean,
the
that was
trial.
the defense argument.
That was the defense argument. But what the trial court said very specifically, and again, the trial court kind of went back and forth on this, but what he landed on, this was right before defense is presenting their case. So before Dr. Kurian comes up to testify, the trial court looks at the cases that we've cited to, Cantori, as well as Saunders, and says, you can't intimate or you can't be putting anything in front of the jury that Mr. Dyer did anything wrong, because he's not on the verdict form as a Fabre, right? And he couldn't be really anyways under those cases. And so what happened when Dr. Kurian was testifying is counsel asked him questions that were couched in hypotheticals but really weren't. And what he said was, doctor, in your 15 years, when they leave you go back to their doctor and they have a change in coronary symptoms. Has there been occasion when you've gotten calls from those doctors about new coronary symptoms? That question can only be going to Mr. Dyer or Dr. Frohan. There is no way that would fit, which is what the defense is arguing. There's no way that fits within their accepted, or I guess that the court allowed them to do, versus Mr. Starr. The question was not, hey, if a patient calls you and says, hey, I'm having new symptoms, what would you do? This was, if a doctor calls you, there was an objection to that, and it was overruled. And then he went on and said, if it's life-threatening, we tell them to go to the emergency room, and then double down on that. When that happens, you tell your patients to go to the emergency room. Yes, that is a critical fact in this case.
But didn't Mr. Dyer indicate that to you?
He did, but
Okay, so what the defendant said is consistent with what Mr. Dyer said. If it's bad, go to the ER.
that is right. But the problem with saying that is that Mr. Dyer, we know from the facts that Mr. Dyer didn't tell Dr. Kurian of that. But we also know that Dr. Kurian could not put blame or try to put blame on Mr. Dyer for not knowing that. And so what happened, and so what they were doing when they had this questioning, and this was in all the argument afterwards, is Dr. Kurian's not only trying to say that, well, Mr. Starr didn't tell me, so how could I have done anything? Now he's injecting, well, Mr. Dyer didn't either, or Dr. Frohan didn't either. That is what is not allowed under the case law.
But I want to back up just a minute. I mean, these are points you raised in a motion for new trial.
Yes.
In ruling on a motion for new trial, a trial judge has not just discretion, broad discretion. Do you
Correct.
agree?
I agree.
And that's because the superior vantage point the trial judge is in, with sitting in the chair of the trial court, listening to things live as they occur, understanding whether it's become a feature, which I asked about a minute ago, whether it's become a feature of the trial, the degree of the prejudicial effect, given the amount of focus or lack of focus on the contested testimony. And so why does this testimony rise to the level warranting the appellate court, who's reading the transcript, from a position that is not as perhaps advantageous as the trial judge, who's presiding in real time and listening to things as they occur? And we're limited to a transcript. Why does this rise to the level warranting our reversal based on the testimony you're referencing?
Sure. So two different points I would make, both from the legal, right, what the law tells us, and versus what the facts are. So under the cases we've cited to from Supreme Court down, the Supreme Court had this, not the same situation, but similar situations, and the Supreme Court said that testimony is irrelevant and speculative. But then they went on in the same case, because the same argument was made, the defenses in this case, that, well, it's harmless error, because there was all this other stuff the trial judge did, same abusive discretion standard, and the Supreme Court said, no, that is harmful error. And they really talked about it in the sense of what medical malpractice cases are. And medical malpractice cases are ultimately end up being a battle of the experts, one, but it's also based upon the medicine, too. What the doctors did and did not do is paramount in that. And to then inject a doctor who is not on the verdict form, who's not there at trial, to say, or to even intimate through a hypothetical, which is what the Cantori was. The Cantori case didn't involve someone saying specifically, well, he did something wrong. It was a hypothetical that was put to an expert. And the expert answered it, but it was based upon the facts of the case, so it mirrored it. And the Supreme Court said that is wrong, because even though it was a hypothetical, you can't do that, because medical malpractice cases, especially this one, going to the facts, are based upon what Dr. Currian did that day. That was the only, there was not a subsequent visit, right, that maybe could conceivably have brought that in, and maybe what he knew and what he didn't know. It was the day that he did that test, and whether he was negligent that day. The argument was made, and the trial court agreed that what happened afterwards ultimately becomes irrelevant to whether Dr. Currian breached his standard of care that day. And so, opposite of what the defense is saying, this doesn't go to a standard of care analysis, doesn't go to what cardiologists would do, because it doesn't deal with what happened that day.
Do they make the argument as to causation, however, rather than standard of care?
They causation, and that really is what those cases go to, because part of it, because that's the whole proximate cause argument of what that is, and they say that you can't have doctors or experts come in and say, well, if this would have happened, then I would have done this, right? And so, and we're kind of going beyond Cantori to then we're now getting into what Cantori also talked about in Saunders, is that's speculation too, right? And so what they were allowing the trial court was allowing Dr. Currian to do is to answer a question that absolutely was under the facts of this case. It absolutely went specifically to Mr. Dyer or Dr. Frohan, depending upon, because he said, like, providers. And then, not just that, but then to go the next step of, if you would have figured that out, if you'd have known that, would you send him to the emergency room? And he said yes. So you're doing both. You're not only getting that irrelevant and inadmissible testimony in through Dr. Currian, but also you're getting in speculative testimony as to what he would have done if he would have known it at that time. And when the jury is looking at Dr. Currian's negligence, which is what they had to look at, I would argue that it's not harmless error when the defendant in the case testifies as to what he would have done and specifically is directed to a doctor that didn't tell him. That's what the facts were.
I thought they did say, you're having him go to the emergency room. Didn't that what
He did. Yeah. The records that, and there was obviously there was some discrepancy with the records that you probably saw, but yes, Mr. Dyer's record said that one of the things was that he to go to the emergency room.
Or the ER.
To the ER.
His symptoms seemed more extreme than they were the
Sure.
5 days earlier.
Yeah, absolutely. And I think if the questions to Dr. Currian would have been posed more as to if a patient of yours does that, because that would have gone within the realm of blaming, or I'm saying blaming, but blaming on Mr. Starr of what he didn't do.
You're in rebuttal.
I'm sorry, Judge. Your Honor.
No, you can use. I'm just letting you know, so you don't.
No, I wanted to answer your question. I'll save the rest of it for my rebuttal time. Thank you.
Okay. All right, you have 4:11 on rebuttal.
May it please the Court, Dinah Stein on behalf of Dr. Currian and Florida Hospital Healthcare Partners. I just want to start by clarifying how the record of how all of this went down and what the rulings were. The original motion in limine, the pretrial discussion, was about you didn't plead Fabre and you can't have Fabre, to which the defense agreed. He said, I'm withdrawing Fabre, I just want empty chair. The court ruled in plaintiff's favor on Fabre, and the next day, sua sponte issued an order withdrawing his oral ruling and saying, I understand now defense wants to argue empty chair. I've read those cases. I'm going to wait until I hear the evidence. This is an issue that's important to the parties, and so he wanted to hear the evidence. At around, I think it was page 1111 of the trial transcript is where the court hears plaintiff's standard of care expert, Dr. Swirsky, testify, and he calls the parties and he said, I'm ready to rule on this empty chair. All of this evidence about Mr. Dyer and what Mr. Starr did has come in already. So what's the problem? And at that point, plaintiff says, wait, but they don't have an expert to testify that Mr. Dyer was negligent. Court says, okay, another argument, but he agreed with plaintiff. So the defense was not allowed to put on any evidence, testimony that Mr. Dyer was negligent. But the jury heard everything else because it was factual. Where the rubber hit the road as far as what plaintiff is arguing is when Dr. Kurian testifies and the court allows defense counsel to elicit testimony that of a customary practice, just to show that it is understood that if symptoms change, it's not a written in stone stress test. Things can change. And so the questions, and we've cited it in the brief, and Your Honors read it, is hypothetical. In your experience in these years, do you ever get calls from the primary or somebody that symptoms have changed? Yes. What do you do? It depends on the symptoms. So he's not talking about Mr. Starr. He just says a hypothetical patient. If they're serious, I say go to the emergency room. If they're not as serious, we make an appointment here.
If I understand Mr. Lee's argument, is that that's not relevant, but the issue is on March 21, your client provided some medical care and testing, did that negligently, and that was the proximate cause of Mr. Starr's death. So whatever happened 5 days after that is irrelevant in the context of how the issues were framed by the pleadings. That seems to be his argument. I don't mean to put words in his mouth. That's how I'm hearing it, and he can explain it better if I'm misunderstanding it.
Right, and that's not the position plaintiff took. They did not say that was irrelevant, and plaintiff was clear all the way through that the defense was allowed to put on evidence as to the subsequent events and not sanitize it as to the fact that he did go to Mr. Dyer. So there was never an objection as to the evidence coming in as irrelevant. The only objection and the only legal error, alleged legal error identified in the brief, is this question and answer to Dr. Kurian. And so they go to the bench after this hypothetical. And this is where plaintiff says, Your Honor, you ruled in my favor. And the court says, don't you see the difference here? I've kept all the rest out as far as Mr. Dyer being negligent, but this is just a hypothetical situation to show the customary practice. I don't know if he used the words customary practice, but he said, don't you see the difference? And they had another discussion, and this is what's critical, because the court ruled during this discussion, I have no problem with what was just asked, but defendant, you are not going to ask Dr. Kurian what he would have done if he had gotten a call from Mr. Dyer or Dr. Fruhan. That was over defense objection. Defense asked for reconsideration later. The court rejected it. So that's, to the extent plaintiff is complaining about causation and Saunders, that wasn't allowed. So, again, this comes down to what's the legal error, and the defendant, the plaintiff has not identified any. At one point during the discussion, during Dr. Kurian, the objection, the motion for mistrial, the court said, you guys, talking to the both sides' lawyers, you're going to play bumper cars on this, I get it, meaning, they were just, everyone was going to push, no one was going to give, and the court had to make some decisions, and we submit these decisions are what falls within the court's discretion. He was at trial, he heard all the evidence, he understood the jury had already heard everything relevant about Mr. Dyer, and the only issue, and again, the only alleged legal error that plaintiffs have identified in their appeal is this one question and answer, and it was hypothetical, and the court even said, don't you see the difference, and had no problem letting it in. So, that's our position on the first issue, is that it's a non-issue because the court ruled in plaintiff's favor, and the jury just heard all of the relevant evidence, and it was just one hypothetical question.
Let me ask you about the third issue. There seems to be some suggestion in the initial brief that the defense theory changed during the course of the trial. The verdict was going to have comparative negligence, et cetera, and then it didn't. It just had an all or nothing, I think was the term that was used in the trial. Is that accurate, or was it ahead prior to the trial? Did it come up that the defense was going to take the position it's Mr. Starr is the cause of his
Yes, Your Honor, and it's inaccurate, and I'll just, go through that. The original discussion, there was a discussion during this pretrial conference, the November 20th one, or motions,
It was a
it was
trial.
motions in limine.
When did the trial start out?
I believe it was a December trial, and the
Okay, so a few weeks before trial that this was being discussed.
was, yes.
Okay.
Yes, and that is when the plaintiff, first of all, the plaintiff said during that hearing, plaintiff's counsel, I have no problem if they want to put blame on Mr. Starr. I mean, and I think, frankly, it was, like, have at it if you want to blame the decedent, and so that was not an issue. But there was a discussion about Fabre, and because there was some confusion, I think, on the part of plaintiff's counsel, defense counsel said at this hearing, I'm not Fabreing anyone, I'm not putting Mr. Starr or anyone on the verdict form. Then the next day, I believe, filed a withdrawal of affirmative defense and said, we are not putting Mr. Starr or Mr. Dyer on the verdict form. So this is in writing, and it even said we reserve the right to argue empty chair. And we've cited throughout trial, Mr. Erickson made it clear, the defense lawyer, we're not arguing empty chair. The verdict form, the last verdict form filed in the record was, there's no evidence of any verdict form other than the general form that
Side
went to.
prepared it.
I believe it was plaintiffs. We had cited in our brief that it was plaintiff's form. I believe it was plaintiff's form because going back through the record, plaintiff had filed a proposed verdict form, which was just a general verdict form, and that's what the parties discussed at the charge conference and what went to the jury. I think maybe the easy answer to this question is nowhere in this trial transcript is there any objection to the verdict form. This was just agreed to by the parties. So, plaintiff, this is why I'm saying it's just inaccurate. This was made so clear to the plaintiffs the entire time before trial that the defense was never going to put Mr. Starr on the verdict form. And the only verdict form, there was one.
But they were going to argue it. That
Yes.
He was the cause. Therefore, answer to question one on the agreed verdict form should be no, at least from the defense side.
That's exactly right. It was
Which is
a
what
very traditional empty chair where the first question would just be, was Dr. Kurian causally negligent? If the jury found that he was, the 5% negligent, well, they got the concurring cause
I mean, they would
instruction.
internally find it. They wouldn't mark that down
Correct.
like the comparative negligence form we use otherwise, but.
Exactly, exactly. But it's like any other case where if he's 5%, they've heard the concurring cause. He's he's in it for the rest, for all of it. But there was no request pre-trial by the defense to put anybody on the verdict form. There was no suggestion that the defense would trying to put anyone on the verdict form, and I'd submit if there was, plaintiff would have pointed to it in their brief. This was raised for whatever reason post-trial, and we made the same arguments, and the court agreed with us because he denied the post-trial motions. So, again, it's not in the record, and I'm just saying once that withdrawal was filed before trial on November, I think, 21st, I don't know that the plaintiff could have legitimately thought we were going to try to put anyone on the verdict form. So that's just inaccurate. And again, the plaintiff always was, I think they were happy to have, and I'm just, I can't speak for plaintiff's counsel, but they never had any issue about blaming Mr. Starr. I almost think they wanted the defense to blame Mr. Starr. That was not objected to. As far as, I won't address the other points unless your honors have
Well,
questions.
what about the second issue about the one expert, Dr. Dewar, was attacking opposing experts' ability, credibility, reputation, or competence, and that was improper under the case law cited in the initial brief?
Sure.
What's your response to that?
And the response is this. First of all, he didn't. He never talked about anybody's reputation, ability, anything that the courts say one may not do as to another expert. So number one, that didn't happen. As to Dr., I think, Pierce, that was plaintiff's causation expert, he did what the case law says he's allowed to do, and that is talk about his methodology and
Dr. Pierce was the cardiologist.
he was a cardiologist. that testified as to causation for the plaintiff.
Okay.
And he was the one who had said if you had only done a different stress test and diagnosed it differently, and 5 days later, he would have had open heart surgery to correct this anomalous coronary artery. And the defense's position was that's just so unrealistic. You know, you just don't go from stress test to catheterization to getting a surgeon lined up to open heart surgery the following Monday after Wednesday's stress test.
And so that was in essence Dr. Dewar's testimony contradicting Dr. Pierce's timeline?
Right. Right. And all he said was, I find it unrealistic. So, you know.
He disagreed with Dr. Dewar disagreed with the ability and that chronology to have accomplished what Dr. Pierce said should have been done if Dr. Kurian was not negligent.
Correct, the methodology. Right, and he explained it, you know, he just explained, and this, most of it came down to what the standard is. He said you'd never operate on this kind of a anomalous coronary artery, but he also said it's just unrealistic to think that someone's going to get lined up with open heart surgery within 5 days when they first have to get a catheterization and, you know, talk to a surgeon, decide if it's appropriate and so forth. That's the extent of it, which the trial court had no problem with at all.
So we look at that ruling under the abuse of discretion standard.
Of course, absolutely. All of these are under abuse of discretion, and that's a lot of what our point is that, you know, the court had to make a lot of, you know, calls, shots, and decide things, and this is just 100% discretionary. The other criticism was, which plaintiff complains about, was their pathologist, who was not an expert. Everybody criticized her methodology. Even plaintiff's expert
That
criticized.
was Dr. Stroh was the pathologist, and she actually did the autopsy and prepared the report, right?
Yes.
Okay.
She did the autopsy, yet did not chart the path of the anomalous coronary artery. And plaintiff's own expert, I think it was Dr. Swirsky, said, or I don't remember which one, but we quoted in the brief, said, that would have been helpful, because where the artery goes shows what the ability is of the rest of the anatomy to cause some kind of a problem. So, you know, everyone was critical of that. But again, that again goes to methodology, which the case law says is very appropriate and in fact good for the jury to hear, because that allows the jury to hear more than just, you know, naked opinions and decide for themselves whose story is more credible. So it was just, you know, that to me was kind of a nothing, because plaintiff's own expert had already agreed.
I understood one of the arguments in the initial brief was that there was improper bolstering with treatises that Dr. Dewar was using to bolster his opinion. And could
Yes,
you
Your
comment
Honor.
on that?
Yes, Your Honor, thank you. So Dr. Dewar did not use any literature to bolster his opinion. The first two things that plaintiff seems to be complaining about was he's talking about, this goes back to his testimony about whether Mr. Starr would even be a candidate for open heart surgery. And he said, you know, this kind of surgery that plaintiff is saying he would have had is so rare that the literature, you know, there's no statistics. We don't have enough cases for a reliable statistic. Plaintiff objects, court says move on, no motion for mistrial. And again, he's just trying to show about statistics. He says it again. He says, you know, well, we don't know what the mortality rate is. Plaintiff stops him again because there's a reference to what the statistics are. The court says move on. He does. No motion for mistrial. So to the extent they're complaining about his reference to statistics, there's no motion for mistrial. It's waived. And I think the Philip Morris case they cite, the Janoff case, says, you know, that's not even an improper bolstering. That's just, you know, talking about what the literature doesn't show. But it's not preserved. The what they're talking about, it's opposite of what plaintiffs are saying. He was questioned about on cross, impeached with Dr. Stroh, the pathologist's findings, because she disagreed with his testimony, and plaintiff used that over objection in Dr. Dewar's cross, saying, well, doesn't the pathologist who did the pathology disagree with you? And and he said, you know, yes, she did. And they had then asked him, well, didn't she rely on literature? Because she put 3 articles in her report that she relied on when she said this was caused by an anomalous coronary artery. And he said, yes, she did. On redirect, the court allowed us to elicit the fact that Dr. Dewar didn't find the articles authoritative. There can't be bolstering if all he's doing is explaining, well, number one, the criticism of him, but two, that an article is not authoritative. So to the extent, they're saying there was bolstering, that would mean he relied on articles to bolster his opinions. He didn't. If anything, it was plaintiff who, because I guess Dr. Stroh was a fact witness, backdoored their literature into the case to show didn't our theory in the report get support from literature. And he said, no, they're too old to be authoritative, and they're not. So again, and I don't mean this to be submissive of plaintiff's theory, but it's just not a theory. It didn't happen. There's no bolstering. And just because they say there's bolstering, they have to point to it in the record, and they haven't. So again, I just go back to the discretion. Just because there are a lot of objections doesn't mean there was an error. And plaintiff hasn't articulated a legal error. They have not articulated where such bolstering occurred. They have not articulated where in the record the defense did something to change the Fabre defendants on the verdict form. It's not there. It didn't happen. And they have not articulated an alleged legal error regarding the one question and answer, I think it was 2 questions and answer, to Dr. Kirian about hypothetical patients and what he does in that situation.
After those 2 questions and answers, then the testimony went in a different direction?
Yes, not to the liking of defense counsel, because that's where the court said you're not only not going to ask Dr. Kirian what he would have done if he had gotten a call on Mr. Starr, you're not going to ask Dr. Kirian whether a reasonable patient like Dr. Starr would have gone to the emergency room. So at that point, the court was done. And the court even said, even though I don't even think it's prejudicial for you to say that, I'm not allowing it. So again, I go back to discretion. The court was being very careful to make this as fair as possible for everyone. The majority of his rulings, I went against the defense on these issues. I mean, with the court even saying, even though I don't see the problem, I'm not going to allow it. So the answer is yes, it went off in a different direction after the defense was not allowed to have him testify as to what he would have done. It went off in a different direction. Again, nothing happened where plaintiff can articulate a legal error backed by a statute, rule, or case law that happened that the court committed. This is all discretionary. So I would submit, the jury heard excellent lawyers on both sides. They heard excellent experts. They considered all of the evidence, and after a 2-week trial, they rendered a very fair verdict. I would submit this verdict should be affirmed. Thank you.
Okay, thank you, counsel. Okay, Mr. Lee, our clock says 4:11 in rebuttal, sir.
Yes, sir. I'm going to address 2 points, and obviously any questions the court may ask of me. The argument you've heard and what's in the answer brief as to why the questions that Dr. Kirian answered or were allowed to answer is that, well, it's relevant to what the standard of care would have been for Dr. Kirian at that time. The problem is that standard of care is irrelevant. If he would have gotten it or if he didn't get it, that's irrelevant to whether he was negligent at the time that he did the test. And so the impetus that they said that was for is, well, we're determining standard of care, we're determining his normal practice, but that had no relevance to what the issues of the case were. Later on, once the trial court says to defense counsel, as counsel just said, hey, we're not going to get into that testimony, the defense counsel, and I think I quoted it in my reply brief, says, understood, and I won't ask those questions about Mr. Dyer. So it was very clear that those questions were intended to go directly to Mr. Dyer and what he did or did not do, not to some standard of care testimony.
Following up what Judge Soud asked earlier.
Yes, sir.
Okay, let's take your argument. All right, so those were irrelevant questions and answers and shouldn't have been permitted.
Right.
Okay. We're all human. We all make mistakes in the course of a trial. And again, following my question, it sounded like what Dr. Kirian said was somewhat consistent with what Dyer said about go to the ER if it's significant. I mean, so my point being is, Okay, let's assume that the question should have been sustained. How is that in the big picture of a 2-week trial so prejudicial that a mistrial should have been granted and we should reverse?
Sure. So, number one, the difference between the two is that in one instance, there's a difference in saying that, well, Mr. Dyer said he should have gone to the ER, so he should have gone to the ER, and Mr. Starr was at fault for not going to the ER. That's one thing. But that was not what Dr. Kern was getting to with those questions. The questioning was not whether Mr. Dyer had told him to go to the ER. The questions were whether Mr. Dyer had told Dr. Kurian about new symptoms. So that is where it is a difference in what they're looking at. Now, as far as is this harmful error, is it not through the course of the trial? Number one, I would submit to the court that to argue that this testimony was something that the jury just would have kind of forgotten about or not thought about, I think is disingenuous, because this was the defendant in the lawsuit. For testimony that the jury is going to be hearing and is going to be, quote unquote, awake for, it's his testimony because he is the defendant. And so to say that this testimony got lost in the shuffle, I don't think is bears out by the record. But I also would say, Judge, that is not our burden to prove on appeal. It's not our burden to prove that, well, the jury would have definitely heard that testimony, and that definitely would have been part of the verdict. We have to prove that there's error. They have to prove that there is no reasonable, under special, that there's no reasonable possibility that error would have.
Did they argue that in their answer brief?
No, they argued it, but very tangentially, and the argument was that, well, it was just a couple of questions out of the entire trial. That was what their argument was. I would submit to the court that when you're talking about a negligence case where the jury is going to have to check no, where counsel has already prepped the jury in an opening statement that if he would have gone to the emergency room, we wouldn't be here, that testimony absolutely is, there could be a reasonable possibility that the jury was hearing that and they were talking about that in the jury room. It's not our burden to prove that they were. It's their burden to prove that there's no reasonable possibility that they weren't, and they haven't proven that. I will, since my time, I would ask the court reverse. Thank you.
Okay, thank you, counsel. Well argued on both sides.